So as we know right now, a number of people are in the unfortunate position where they hold a 482 visa and they've lost their job through no fault of their own. But what makes this situation even more difficult is these businesses that have closed down have left the visa holder in a situation where they're unable to work for anyone else. There's a visa condition attached to these visas, as most visa holders know, which mean that you can't work for anyone else or you can't work in a different occupation. So the problem that we're faced with is in the lack of any welfare support payments from the federal government to 482 temporary visa holders and other visa holders, that they're not going to be able to cover their basic needs for living, access to money for food, support, medicals, a whole range of issues. Now, the federal government could change this by relaxing their position on the 482 visa limitations. I've written to the department on a number of occasions. I've spoken to the department and I've sent them a recommendation on what I think they should do to implement some reform which will help all 482 visa holders affected by the coronavirus. Essentially, these changes would be the department would be able to exercise their discretion under section 1161B of the Migration Act to not cancel any 457 or 482 visa holder who does not work for their nominated employer and who does not work in their nominated occupation. And this would give those visa holders an opportunity to support themselves in the absence of any government entitlements or welfare payments available. And most importantly, the Department of Home Affairs and Australia Border Force would not refer any employer for investigation of any potential breach of Section 245AC of the Migration Act. Now, that would be the easiest thing for the department to do. Implement these reforms to make it easier for people to support themselves. Now, if the department don't implement these reforms, we need to come up with a pathway or a solution for visa holders to be able to get access to work, to be able to support themselves. Now, at Migration Solutions, we've come up with what we think is, at the moment, a viable option, but this will ultimately depend on what the department do with regards to relaxing the 457 and 482 visa limitations. So in a situation where someone loses their job, what they may be able to do is go to the immigration department and voluntarily request their 482 visa be cancelled. So I'm going to ask the department to cancel my 482 visa. Normally you wouldn't want to do that, but if you do it, you could be granted a bridging visa E. On that bridging visa E, you can request permission to work due to financial hardship. That's one option. That does create a bit of a problem, and more than likely what you'll need to do is then lodge an appeal to the Administrative Appeals Tribunal to appeal the decision to cancel the visa, because that will allow you to extend the time that you can remain in Australia. During that time, you can stay here, you can live and work. For some people on a 482 visa holder, once it's cancelled, they may still have an opportunity to look at applying for another visa, such as a general skilled migration points tested visa. To do that, they'll need to do a skill assessment. Once they've done the skill assessment, if they meet the eligibility criteria to apply for permanent residency, unfortunately, they won't be able to do it because they'll be affected by Section 48 of the Migration Act, which says if you're in Australia and you hold a bridging visa and you've had a visa refused or cancelled, you cannot lodge an application in Australia. Now, I've written to the department and asked them to waive Section 48, because if they do that, you could still then lodge an application for permanent residency through the skilled migration program without having to go overseas to do that. And we know you can't go overseas right now because of the travel bans. If the department don't relax their position on Section 48 of the Act, then what you're going to have to do, once you lose your appeal at the tribunal, is go to the minister. Go to the Ministerial Intervention Unit and lodge an application for ministerial intervention. And during that request, you would be asking the minister to either waive Section 48 on a case-by-case basis, allowing you to apply for your permanent residency in Australia, or you would be asking the Ministerial Intervention Unit and the minister to maybe grant you a 12-month visitor visa with work rights, which would then allow you to continue staying and living and working in Australia. But most importantly, it would then grant you a visa, which would mean that Section 48 of the Act doesn't apply and you could lodge an onshore application for permanent residency. Sounds very, very complicated. The easiest thing for the department to do would be to waive the conditions around the work limitation on the 457 482 visa. If they don't, there are other solutions that we can look at. They are a little bit complicated, but at least there's something there. At least you can take some hope that you will be able to stay in Australia and we can get you access to work rights to support yourself during these challenging times. If you've got any questions about your individual situation and how it affects you, contact Migration Solutions. You can get in contact with us through Facebook, by email, by phone, and even though we're not doing face-to-face meetings at the moment, we're able to make an appointment with one of our 5 registered migration agents who you can speak to about your individual situation.